All right. Whoops, I'm getting a little click happy there. All right, this is Karen Thompson with Ask Resource Center, and I'm here with Nathan Kirstein from Disability Rights Iowa, and today's webinar is Privacy Laws for Parents Part 2, What You Should Know About FERPA. The Family Educational Rights and Privacy Act, also known as FERPA, is a federal law that protects the privacy of students' educational records. The law applies to schools that receive funds under an applicable program of the U.S. Department of Education, and it gives parents certain rights with respect to their children's educational records. Those rights transfer to the student when they reach 18 or when they move to a school that's beyond the high school level. But the question is, what does that mean to you as a parent or as a professional who serves kids? And that's what Nathan is here with us to talk about today. Nathan's a graduate of the Drake University Law School and a staff attorney, you're an attorney, a staff attorney at Disability Rights Iowa. He provides representation and advocacy to individuals with disabilities, focusing on special education and juvenile justice. He previously worked as a contract attorney for the Public Defender's Office in Des Moines and is very involved in community activities, especially those relating to children and youth. Thanks for joining us today, Nathan.
Thank you, Karen, for having me. So as Karen pointed out, this is part 2 of our privacy law series. We started out with Health Insurance Portability and Accountability Act, otherwise known as HIPAA, and today we're going to talk about FERPA, which is the Family Education Rights Privacy Act.
Oops.
And we've already introduced ourselves. I am not Jane Hudson. I am Nathan Kirstein. But other than that, we can move on to the next slide.
As far as funding for Ask Resource Center goes, this webinar is produced from a grant from the U.S. Department of Health and Human Services called Family to Family, and the project here in Iowa is Family to Family Iowa. And then also the grant that paid for my time on this project is the Parent Training and Information Center grant.
And Disability Rights Iowa funded this webinar through a subcontract with Ask Resource Center under Family to Family Iowa, and a grant from U.S. Department of Health and Human Services, Administration on Community Living, Administration on Intellectual and Disabilities. We always give a disclaimer at the beginning of a webinar such as this. As any good lawyer does, we want to make sure that you understand what the relationship is as we go through this webinar. First of all, this is for informational purposes only and not for the purpose of providing legal advice. If you actually have legal questions concerning FERPA that are specifically related to you or your student, then it's best to contact an attorney. And this webinar does not create an attorney-client relationship between Disability Rights Iowa and the listener. So that aside, let's talk about FERPA. FERPA was enacted in 1974. Prior to that, there were issues with rights of access for a parent to access their students' information. So, a mother could be informed that she has no rights to the records resulting in her child being transferred to a class for individuals with developmental disabilities, as an example. Also, prior to the enactment of FERPA, there was no right to challenge disclosures to others, meaning the school could pretty much give your records to any other person, and there's no reason to, or there'd be no way to challenge that. Also, you know what? I think I'm a little bit off on this webinar slide, so bear with me here. Next is having to do with there was no right to challenge any type of issues that you saw in the records that were not appropriate or you felt were not truthful or something of the sort. So Congress enacted the law, FERPA. The statute is found, as you can see on the webinar, and then regulations were enacted in order to follow that statute. And then there's some good laws and guidance on the website that is the last bullet point on the slide. We've already talked about the purposes of FERPA, which is to change the issues that Congress saw prior to the enactment of it, which is to provide a right of access, to make sure that inaccurate or misleading records could be amended, and to limit the disclosure of records without parent consent. So who has FERPA rights? Parents or guardians, and there might be a question about foster parents. In that instance, foster parents want to look at the court order that assign them as foster parents. Usually that's going to say something on it regarding educational rights of the child, or it might be silent. And if it's silent, you may want to ask the clerk of court if you don't understand, or the DHS caseworker. Many times, the educational rights, the educational decision-making rights, stay with the biological parents if there are biological parents, and therefore they do not transfer over to foster parents without that specified in the court order. Also, if parents are divorced or separated, parents should look at the decree. If they're shared custody, usually they're shared decision-making power for educational decisions. So that should be looked at to see who retains educational rights. And then when a student turns 18 or enters a post-secondary institution, if they enter that prior to the age of 18, the FERPA rights transfer to that student.
Nathan, for some of our parents who might not know what post-secondary institution is, can you describe what that means?
Yeah, that would be anything after high school, like a community college, a four-year college. Sometimes vocational programs might qualify as that.
Great, thank you.
So, just to keep in mind, FERPA is basically a confidentiality and privacy law. Now, the IDEA, the Individuals with Disabilities Education Act, actually incorporates most of the tenets of FERPA into that act. We'll be talking about FERPA today, but it's just important to recognize that there's no conflict between FERPA and IDEA. So first of all, let's look at which schools are required to comply with FERPA, and then what records are covered by FERPA. In terms of which schools are required to comply, that would have to do with educational agencies and institutions that receive federal funds under any program administered by the U.S. Department of Education. It's important to note that that says U.S. Department of Education. No other federal funding qualifies an actual agency. So it's something to pay attention to. So that might be in the instance of a school that receives free and reduced lunch type funding, but doesn't receive any other federal funding that would have to do with the U.S. Department of Education, then that school does not have to comply with FERPA because the free and reduced lunch program is not funding under the U.S. Department of Education.
That program is funded through the U.S. Department of Agriculture, is that correct?
Correct.
Okay. Is there a place that folks on this webinar could go to find out what types of funding, what department would fund different things, or is that something that they should maybe ask an attorney or ask an advocate?
I think I'd ask an attorney or advocate as the quickest way to do that. And as we move forward here, you'll see that on the next slide, this virtually applies to all public schools and school districts. The only time this might come into conflict is when you're looking at a private school or something like that, but we'll get to that in a moment.
Great, thanks.
So as I said just a second ago, FERPA applies to virtually all public schools and school districts, post-secondary educational agencies and institutions, so like I said, community colleges, four-year colleges, things like that. Charter schools, I know there's not really any charter schools in Iowa, but it does apply to charter schools because they're federally funded. And then it applies to Head Start as well as state licensed and regulated child programs that because they receive IDEA Part C funding. So that would be funding under the Department of Education. So which agencies do not have to comply with FERPA? That would be private schools in general. Once again, as we talked about before, that might have some differences there, and one of them might be that if they somehow are receiving Department of Education funds through Part B of the Individuals with Disabilities Education Act through a contract with a public school, then you might have an argument that FERPA applies in that case. But that would be something I would talk to an attorney or an advocate about before making that assumption. Also, homeschooling. If you're not dual enrolled, if your student is not dual enrolled, which means if they're not enrolled partially in the school district and partially at home, and that's usually done so that the student can receive special education services through the school district. If that's not the case and you're just strictly having the student at home being homeschooled without any services from the school, then FERPA does not apply, which I'm not sure why you would want to argue with yourself about getting educational records from yourself, but nonetheless.
You probably wouldn't have any records in that case, unless you had some from previous years, maybe, that
Exactly.
were relative to something.
What records are covered by FERPA? So that would be educational records, which are records, files, documents, and other materials which can contain information directly related to a student and maintained by an educational agency or institution or by a party acting for an education agency or institution. That last part, by a party acting for an education agency or institution, would be kind of what I described earlier, where a school district contracts with a certain private entity to provide a classroom, let's say for youth with behavioral needs, something of that sort. That entity that's contracted with the school district would be covered by FERPA.
So I have a question about that, and this is something that has just recently come into play with a couple of cases that we're working with, where the student goes to a private school, but they have a 28D agreement with a public school to provide like advanced placement classes, those kinds of things. Is that type of a relationship something that would qualify here? If one of those students is on an IEP and receiving advanced placement?
I would say I think a good argument could be made that it does.
Okay.
Because it would be a contracted entity with a school district, and a school district is going to be a public entity that's already underneath FERPA, right?
Right.
And especially if that contract, I think there'd be a really good argument, not only with the contract there, but if that contract has money that is coming from the feds in any way under the Department of Education. So a kid on an ID or IEP is going to have funds from the IDEA that flow through the U.S. Department of Education. So I would say absolutely.
Great.
Okay. So personally identifiable information is protected by FERPA in educational records. So that would be any information that could be used to identify a student with a reasonable certainty. Use your common sense in this. This is going to be stuff like name of parents, family members, address, social security number or student number, date or place of birth, mother's maiden name, that type of information. So let's go through a scenario in order to review what we've learned so far about FERPA. And that would be to talk about a 7-year-old girl by the name of Alice. She's got a mom, dad, 2 brothers, and 2 dogs, enjoys making cakes and doing arts and crafts. She has epilepsy and an intellectual disability. She's on the intellectual disability waiver. She receives general education in an integrated 2nd grade classroom in Walnut Elementary School. She has a paraprofessional who helps her in the classroom, and she receives occupational and physical therapy services. So the key part about this is, first of all, does FERPA, or does Alice's school have to comply with FERPA? And so when we look at what schools have to comply, it looks like she goes to a public school. So yes, because the Educational Institute receives federal funding from the U.S. Department of Education, her school has to comply with FERPA. Also in Iowa, when we look at area education agencies, the AEAs, they must also comply because they receive DOE funding as well. What would Alice's education records be? Grades, copies of her work maintained by the schools, reports by consultants, health plan and medical records kept by the school nurse, IEP, the BIP. Also, discipline records, emails between teachers, paraprofessionals, and administrators, meeting notes about Alice, health and immunization records maintained by the school, and records on services provided under the Individuals with Disabilities Education Act.
Can you talk a little bit about what you mean by meeting notes? Are those things that the teachers are sharing back and forth?
Meeting notes would be any note that, okay, if you have an IEP meeting, let's say, for instance, and notes were taken at that meeting and may not be incorporated into the IEP, you have access to those notes. Or it might be a disciplinary meeting where you sit down to talk about, hey, Alice has some behaviors in this classroom. How are we going to work together on this? Whatever notes were taken at that meeting, I would say are accessible under FERPA.
Thank you.
So what would not be one of Alice's education records? These things in this list are not educational records under FERPA. That would be records in sole possession of a teacher or substitute, such as teacher desk notes. Think of this as kind of lesson plan info that a teacher might write regarding what she's going to do, she or he is going to do in class that day, or something of that sort. It's mainly just kept for themselves as a reminder or something of that for themselves. It's not something that has to do with an individual. It doesn't have to do with necessarily an IEP or anything of that sort. Okay? It's more of a general note written by a teacher for a teacher's self. Also, records maintained by law enforcement unit for sole purpose of law enforcement. This would be, your basic police reports, things like that, that may be created if law enforcement are called to the school in order to investigate something that's a criminal matter, right?
Now
However,
go ahead. I think you're going to touch on what I was going to ask you. So
sometimes we know this happens where educators share educational records with the law enforcement. Those records that are educational records don't lose their status as educational records by them being given over to law enforcement. That means you have a right to see what law enforcement has that the school has given them in terms of educational records.
What about a school resource officer who is a law enforcement officer but subcontracted to provide school resource officer services kind of on the side or in a moonlighting type situation, and a piece of information is created by that school resource officer, but it's inside the school?
I would say I think you can make a good argument that that is not records maintained by a law enforcement unit for the sole purpose of law enforcement. Because my guess is going to be in situations like that, oftentimes the school resource officer is using those records or whatever their notes are or whatever they're doing. That's being used in the educational setting for ongoing, usually intervention with that student, rather than let's see if this student has indeed committed a crime and are we going to file it with the county attorney's office. That's what I'm talking about, is that last part. Did the student commit a crime? What's the evidence? And are we going to file it with the county attorney's office? That's the type of stuff that's not educational records.
Great, thank you.
And then school personnel records. You know, obviously, what the school does with their employees, and the superior to employee or employee to employee in terms of personnel stuff, that's not your business under the law. Sometimes we might wish it was our business. So what other records would not be covered by FERPA? Treatment records by physicians, psychologists, or psychiatrists, which are not available to others providing treatment, and directory information. So you've probably all seen school directories or something of the sort in which that lists student names, telephone numbers, things like that, grade level, participation in sports or activities. That's not covered by FERPA. However, just a note, you can opt out of those, and there's ways to opt out of those, usually written on the school district's website or in their policies. So, are medical records maintained by schools covered by FERPA? Yes, if health information is sent to school or school nurse employed by the school or acting on behalf of the school, the medical records become education records, and FERPA controls.
So it's similar to the school resource officer situation, even if the clinic is maybe a subcontracted nurse, if they're operating on behalf of the school, that's an educational record.
Correct.
Okay.
Correct. And that is why you're not going to see a lot of conflicts between HIPAA and FERPA, because you're oftentimes not going to come into a situation in real life where the nurse or person providing health services at the school has nothing to do with the school unless they're your own private nurse or private healthcare provider that's somehow doing that there. But then that's not even related to the school anyway. You know what I mean? So you're rarely going to bump up against the case where you're not going to be able to, those records aren't going to qualify as educational records. So now that the basics are covered, let's discuss rights of parents and eligible students under FERPA. So they have a right to what? Access education records. They have a right to try to amend inaccurate or misleading records, and the right to limit the disclosure of records without consent of the parent or student. And schools must provide parents and eligible students with notice of FERPA rights on an annual basis. So every year you should get something that tells you about FERPA rights, which we all probably get those and file them in the trash can. So, number one, the right to inspect and review your child's records. The school has to respond within a reasonable time, which means they have to respond within 45 days after your request is made. You should make that request in writing. It's not required by law to be in writing, but as us attorneys like to say, if it's not in writing, it never happened. So it's a good practice to be in. So definitely make your request to the school district or the AEA, wherever you're trying to get your records from, in writing.
And date it.
And date it at the top, exactly. Kind of like a regular letter. Then the school has to respond to these reasonable requests, and the court decides what's reasonable. So don't worry too much about what does reasonable mean. You're probably reasonable if you got a good head on your shoulders, and you're asking for records that are your students' records for educational purposes, right? So the school's got to respond to that request, and if you have questions, they also have to provide explanations and interpretations of the records if you have trouble understanding them. A lot of educational records are kept by the school that have a lot of different terminology in it that you may not know. That's kind of insider baseball. And so it's important to ask the questions because the school does have a duty to explain those things to you. Also, the school has to provide copies of these records if somehow you're prevented from inspecting or reviewing them, somehow can't get to them. Maybe it's a long distance, you're requesting records from a former place that your school or a former school district that your child went to that may have some records still. That might be an instance where you get copies. They may charge reasonable, they meaning the school district or AEA may charge reasonable fees for copies, but they can't charge, ridiculous amounts of fees that would basically keep you from getting the copies because you'd say, I can't afford that. Can't do that. And if there's an outstanding request, let's say you've made a records request, that puts the school on notice that they cannot destroy any records they might typically destroy in their normal course of business. What limitations exist on the right to inspect and review records? If the educational records of the student contain information on more than one student. Okay? A perfect example of this is bullying complaint forms, bullying investigation forms, things like that you want to find out information about what happened with your particular child in that instance. You can get those records, but those records are going to be redacted with any identifying information of the other student or other students taken out, and that could include what the consequences were for that student, so keep that in mind. Also, you don't have the right to, an eligible student does not have the right to inspect and review records that are financial information about parents, if they're in a post-secondary institution, nor do they have the right to inspect letters of recommendation if that student has already waived that right. So let's talk about a situation. We're going to revisit Alice. The parents and school disagree about Alice's reading goal. A compromise is reached that the school's consultant will collect data on Alice's reading abilities on a daily basis for a period of time. At the end of the data collection period, the IEP team will meet to consider data. The parent does not receive any data information per the agreement, requests it several times, has given vague reasons why it's not ready. Parents ask if she can just look at the collection log and is given another reason. Suspicion grows on the part of the parent. The data is not really being collected. They talk with the principal. Again, several days go by without any data being given to the parents. I'm sure you all have been in a situation possibly like this. So then the IEP team meets and the data is produced that supports the school's position that the student is fine and reading goals are being met. Parents want to challenge the data that is shared. So what they want is to review the data from the raw data from the reading log observation checklist. Can they do that? So what law applies? FERPA in this instance. Is the raw data an educational record under FERPA? Yes, it's an educational record under FERPA and IDEA because it contains information directly related to Alice and it's maintained by an educational agency or institution or by a party acting for an educational agency or institution. Do Alice's parents have a right to inspect and review the raw data? Yes, of course they do. As soon as possible, but definitely within 45 days after their request, which is going to be in writing and dated. And they have a right to have the records explained to them and possible copies of the records. Which gets us to the next slide, which, yes, they do have access to copies of the raw data, and they may have to pay a fee, but that fee cannot be a large fee that would keep them from being able to pay that fee. Now, let's say you run into a school district that says, well, we're going to charge you $500 a copy, which probably won't, but let's just say you run into this scenario. Well, my advice is to talk with the superintendent of the school district or the AEA Special Education Director at that point in time, and then follow up in writing. The reason why I say that is because the formal process that's allowed under this act, under FERPA, for complaints is not really designed to provide you with a solution right when you file that complaint. And so I don't think it's a real good option if you're in a situation like this to try to get your records and get them in a timely way and get that huge fee waived. I think it's easier and probably get better results and quicker results if you talk to the superintendent of the district or the AEA Special Education Director.
Might it be possible that that you could offer a solution like provide electronic copies or a scan or something like that, where it's not going to cost them time to run it off and their copier wear and tear and paper and all those kinds of things, or maybe just a little bit of the things you originally wanted copies? Is it a reasonable thing for parents to go with a couple of solutions for the superintendent?
Yeah, the more solutions, the better. Or if you live in a smaller town, or you live in a school district that's in the school that you're actually looking for records from is right next to a copying center or something like that, ask someone if they wouldn't mind running over there with you with the file, and then pay for the copying there at a reasonable price. So that's kind of some solutions, and those are good ideas, Karen. Thank you. So when Alice turns 18, or when she enters a post-secondary institution, the FERPA rights transfer from her parents to her. How can a parent or eligible student request amendment of the student's educational records? So, parent may ask educational agency to amend educational records of the student if that record contains information that is inaccurate, misleading, or somehow violates the student's privacy rights. Once again, that should be done in writing. And the educational agency may respond with a yes within reasonable time. And at that time, well, we'll go into what happens at that time in a moment. They may say yes, or they may say no and say, you have a right to a hearing. This is not a hearing like a due process hearing under the IDEA. This is a separate type of hearing. And what happens at that hearing is conducted by a person who does not have a direct interest, which could be someone that works for the school district or the AEA, but doesn't really know about what's going on with this particular student and has no real direct interest in it. So then you do have an opportunity to be represented by any person, including an attorney in this type of hearing. Evidence can be produced on both sides, meaning witnesses as well as paper evidence. If the parent wins, the record is amended. If the parent doesn't win, then the parent has a right to place a statement in the education record as to why parent disagrees. So, if you take all of what I've just said about the amendment of records as a whole, what you should get from it is, one way or another, you're going to get your 2 cents worth into the student's record, one way or another, either through the actual record being amended by either the school saying yes to your request, or the person doing the hearing saying yes, right, will get amended. Or if the school district says no and you still don't win in the hearing, then you still get the right to at least put your statement, your 2 cents worth, into the record, so that when someone else looks at that file, they're going to see both the record that you felt needed to be amended, as well as what you thought needed to be corrected in that record.
That's a great time to engage advocates. Really, probably, unless it's something fairly significant, you might not want to use an attorney's time or pay an attorney's time for that. But if you want some assistance writing what you want your statement to be in a very factual way that gives any reader a very clear, concise idea of what it is that you wanted to state without the emotion in it that some of us parents can sometimes feel when we're having a conflict with a school. Advocates are a great place to turn to help you with those kinds of things.
Exactly, and this might be something that's very important because, as we know, school records transfer from place to place, and sometimes what's written in those can be great for the child or can be really poisoning to the well if they're going to try to start anew in a new district or new placement. So really, this can be very important, and what Karen said is very true. If there's a need for an advocate, I would recommend that as well.
The reasonable time on this, is it the same 45 days that it is when you're, as you were talking about before, is reasonable time different for
Reasonable
amendment?
time is not defined in this instance, but I think you can make a good argument that 45 days is what's allowed for you to get records. So you should say, hey,
it's a lot of time.
That's a lot, yeah.
Yeah.
It's a good amount of time.
Great.
All right. So we're going to go back and revisit Alice real quick. Here's the situation now with Alice. Neurologist report states that Alice should be allowed to recover from any seizures for an hour in the nurse's office. But the nurse's records inaccurately indicate that she can recover in either the nurse's office or in a quiet corner of the classroom. The nurse shares this information with Alice's teacher and paraprofessional. So, what can Alice's parents do to correct the nurse's records if they don't agree with them? First of all, what law applies? FERPA, because the neurologist's recommendations and the nurse's records are educational records. And are nurses' records inaccurate? The parents believe so. What is the process for parents to get records amended? Ask for the amendment in writing. School must decide in a reasonable time. If the school decides the records are inaccurate, then the school must amend the record. If the school decides not to amend, it must inform the parent of their decision and the right to a hearing. That should be in writing as well. And then if the hearing official decides that they're not accurate, then parents can put if the hearing official decides that they're not inaccurate, meaning decides with the school, then parents can put a statement in the record about why it is wrong. If the hearing officer obviously decides that with the parents, then the record is amended. Okay, FERPA right number 3, the last right under FERPA. Disclosure. Education agencies and institutions cannot disclose educational records to others without the consent of the parent or eligible student, except in limited circumstances where no consent is required. So, what is consent? Parent or student provides a signed and dated written consent to an educational agency, and that consent must specify the records that may be disclosed, state the purpose of why they're being disclosed, and identify the party or class of parties to whom the disclosure may be made. So all of that says it should be very specific. Large general consents aren't necessarily a good idea.
What's a class of parties?
So that would be more like, I think of that more as a student with multiple mental health care providers. They got a few different people working with them from one agency or multiple agencies. Then that might be a class of parties.
Okay. And I think that's an important thing for parents to understand, that even though those people may all be involved in, that's a perfect example, mental health care or mental health treatment for a child or behavioral treatment, we all know what happens when you play the game telephone, right? So you don't want to give a broad blanket release for everybody to talk to each other, or sometimes things can get misconstrued and you can end up in a situation you didn't want to be in. So this helps protect you in that way.
Right, exactly. And then upon request, the education agency must also provide a copy to the person giving consent. So if you're signing one of the AEA's forms or the school district's forms for consent to allow them to disclose educational information and records, you can ask for a copy of that form that you're signing.
So these aren't typically done as letters. These are usually forms that the schools have.
A lot of times, yeah.
Okay.
I mean, that's how I see it. And, I mean, I know the AEAs in school districts in Iowa, all the ones I've worked with have forms for that.
One of the things for parents to watch out for, I've seen some schools recently that will try to put through a release that says, you know, for the school nurse, for these 10 people at the school, and also for anybody at the AEA who wants to see it. And then they'll say, go ahead and sign this so we can share the information we need to share under FERPA. You don't have to sign it that way. You can strike those pieces out or have a conversation with your school about, you know, who are the 1 or 2, maybe 3 people who need to be on this release.
Exactly. Remember that this is your right as a parent or the eligible student's right to consent. It's not, you're not doing, keep that in mind. This is about you, I guess is what to keep in mind, or the student, okay? So that you're not feeling pressured that you must consent to this, that, and the other thing, because they're doing you a favor by asking you for your consent.
And usually they're very open to that. If you come back and say, I'm just not comfortable with this, and really these are the 2 or 3 people who I think need to know, most AEAs and schools really want to work with you on that, and they might have had a more broad release in place for something else and didn't even think about it. So point it out and explain what you want and why, and 90% of the time or more, you're going to find they'll be very happy to work with you.
Exactly. Forms are forms. Remember that. They're always subject to change. Under what conditions is prior consent not required to disclose information? Meaning, the school does not have to get your consent or the eligible student's consent in order to disclose the educational information. That is when it's being disclosed to other school officials, including teachers who have legitimate educational interest. We'll talk more about that in a bit, what that might mean. To officials of other schools or school systems in which the student seeks or intends to enroll. To officials in juvenile justice and child welfare systems. In emergencies to protect health and safety. In response to court orders or subpoenas. And in connection with financial aid applications.
Uh-oh, Alice.
So, yeah, Alice is having a heck of a time here. Alice throws a chair at another student. The principal tells the school resource officer that she is receiving special education services. So what do we got going on here? Did the principal violate FERPA? Yes, the principal violated FERPA when he disclosed information about Alice to a school resource officer because that's not an emergency to protect the health or safety of the student or other individuals. I would say something more about this as well. Sometimes, or I would say more times than not, you want the school resource officer to be informed if there are behaviors that are manifestations of the student's disability. You want them to be informed as to what those behaviors are and what the behavior intervention plan is for that. So if they do have to work with your student, and hopefully they don't, but if they do, they're at least aware of that. But that can be done through the consent that we just talked about. Signing a consent to allow them specific information, like maybe the behavior intervention plan or something of that sort. But they don't need to know everything and anything about your student, and their entire IEP probably don't need that either. One other thing about this chair throwing incident, the school could disclose that the details of that incident and other things to teachers and school officials who had a legitimate educational interest in the behavior of the student. So that might be a para that works with the student that was not in the room at the time, something of that sort.
So another place I've seen that a lot is on buses. If behavior is happening on buses, then it is important for the bus driver to know, for example, or for a para that rides with to know.
Correct.
Would that be an example
Correct.
of that? Okay.
Specifically, if you have some type of transportation services as part of the IEP, then absolutely that information can be shared because they have an educational interest, because it's actually part of the IEP, and should be shared.
Great.
What record-keeping requirements exist concerning requests and disclosures? So any type of consents or things like that you sign, the educational agency must keep a record of requests for disclosures and redisclosures. That record must include the parties who have been requested or received personally identifiable information from the educational records and the legitimate interest the parties had in requesting or obtaining the information. So kind of like a log.
Whoops, I pushed the button too hard. Sorry, guys.
So back to Alice. So now we got maybe the school not necessarily behaving appropriately in a few different instances here rather than Alice's behavior that we're going to look at. So Alice's parent is in a school office to give a note to a secretary to notify everyone about an upcoming appointment. While she's in the office, the secretary clicks through screens with extensive information, both medical and school records, about Alice. Her parent is concerned about which school personnel have access to what information. Do schools need to create a hierarchy of data access to specific information? Does the school secretary get to see Alice's medical records? Is that appropriate under FERPA? FERPA does apply here. We got medical and educational records directly related to the student and maintained by the school. FERPA requires that those educational records be shared only with those who have a legitimate educational interest. I don't really think the secretary has a legitimate educational interest in this scenario, so she or he should not have access to those records. So the school needs to protect records through physical, technological means and administrative policies. There should be a policy with every school district as to how they protect student records and information. We have another situation here with Alice where the school has had a practice of leaving entire IEPs in a notebook in a common area on the table so parents can look up student IEPs. Very convenient, but might be problematic, right? Because anyone in the room, in the classroom, can look at that, including other students and other people, parents that might be visiting the classroom. So what do we do about that type of scenario? Of course, FERPA applies. The IEPs are definitely education records. And the school can only disclose those without prior consent to school personnel who have legitimate educational interest. So that's not anybody and everybody that happens to walk by that table, including students. So there should be some other type of way of getting this information to the paras without having it exposed to everybody else. Once again, there should be a policy about that. And if the school district doesn't have a policy, they need to. Now, once somebody else has educational records that you have provided consent for them to have these records, what limitations apply to them redisclosing, sharing that information with somebody else? So, in the consent form, let me just say this about redisclosure. In the consent form, there should be something, language in there that says that other entity, person, agency will not disclose the information to any other party without the prior consent of the parent or eligible student. If it doesn't have that language, it doesn't mean that that's not the law. So at the end of the day, you need to be able to provide consent when that party that received the educational information, if they want to redisclose it, they got to get consent from you as well. So kind of FERPA just travels right along with that educational information when you sign a consent.
As advocates, that's something we really encourage families to ask as they're signing consents, to say, now in terms of redisclosure, you won't redisclose this to anybody else without asking me first and getting a signature again, right? And usually then that allows the entity you're working with to say, yep, it's right here on the form and our policy is to not do that. But that way that opens the door for that open conversation about it, and you can let them know your expectations and that you understand your rights under the law.
There is no right, like a private right, to sue for FERPA violations. There's nothing written into the law about that. So the complaint process is quite lengthy, and you have to file, if you want to file a complaint because you believe a FERPA violation has been made, then you file it with the Family Policy Compliance Office noted on this slide. You have to do so within 180 days of the date that you knew or reasonably should have known about the violation of FERPA. And then what happens is, if there was a violation, if they do find there's a violation, then there's a little report written to the school district or whatnot about what it is they have to do to comply with the law. But that's not necessarily always a fast turnaround, and it may not necessarily get your certain issue resolved in a way that you would like. So I would say, if you're concerned about FERPA, any type of violation, try to go to the school district superintendent. If they're not hearing you out, then reach for the special education director at the AEA. If they're not hearing you out, talk to the Iowa Department of Education and find out what can be done. Talk with Karen's agency at ASK, or talk with Disability Rights Iowa. But try those resources before trying to get something done by the U.S. Department of Education. Not because they're not good at what they do, but because, usually you're asking for this information or something's of concern for a reason, and usually it has to do with something that you want done, a solution you want done right then, not a year from now. This slide just has some useful resources that you hopefully can use on your own time and when you have questions about FERPA.
And I think we talked through most of the questions as we went. And I know when we have provided this webinar in the past, we've gotten comments that it was very useful and comprehensive. Hopefully everybody listening to this recording feels the same way. An evaluation reminder, there is a link to the evaluation on the recording or next to the recording. There's also a link to the PowerPoint presentation in a PDF format. So feel free to upload that if you want access to the slides. And if you've listened to this recording, please make sure that you fill out the evaluation. That's how we keep the grant funding in place that keeps informational webinars like this coming to you. Thanks for your time today. Have a great day.
All right.